Hello, my name is Austin Gilly, and my fatherhood is on trial with AI. At this point, the adversarial process was drowning out the guardian ad litem, who was the children's court appointed attorney. But she insisted on a Father's Day visit in 2023 and continued contact between me and my children. This was a position she reached after mom and dad's depositions. Claude reviewed those transcripts, 350 pages of sworn testimony across 2 days. The following is what Claude found and notes as important. Asked when mom first informed dad of the divorce filing, she testified that she had told the children the night before she told dad. Why? She said, "I wanted them to have the opportunity to share their thoughts and feelings without having their dad there." At the end of the deposition, her own counsel followed up. 3 things came out: no physical abuse to report, the abuse she alleged was mental or verbal only, and her position from the beginning had been joint custody. Her own attorney asked, "It has always been your want and need for the father to be a joint custodial parent." She agreed. Earlier in the same deposition, asked whether the children had ever had a positive relationship with their father, she said, quote, "I don't think so." Each child, never, in 16 years. Asked why she had married their father if her impression was so negative to begin with, she clarified that her impression was negative before we ever started dating. My deposition followed on May 19th. The guardian ad litem sat in. Mom's attorney examined me. He did not start with marriage or the filing. He started with a 2008 employment case from 15 years prior, my whistleblower retaliation claim against the state. Claude found the opening exam ran for about a third of the day. The psychological evaluation I had obtained at the time, anticipating I would be accused of being unstable for refusing to back down, would become the attorney's foundation for the architecture he had built in his May 8th motion. The motion arguing a pattern of behavior stretching 15 years from 2008 to 2022. The questioning wasn't building toward a new motion. It was filling in the one already on file. The rest of the depositions surfaced things under oath that had stayed inside the family until then. Mom testified that her parents had begun working at a children's home when she was 5 years old. Her father started as support staff, then earned his master's in social work and became the children's director. When mom was in junior high, both her parents took on the role of house parents, caring for up to 12 children at a time, similar to having foster children. Claude observed that her parents had served as institutional substitute parents for most of their professional lives. Dad's deposition surfaced the rest. About the homeschooling, quote, "We homeschooled together. About 2 years prior to separation, I was ultimately the lead in homeschooling." About March 2021, conversation with my in-laws and my wife present. They told me in 2021 that if I didn't give her what she wanted, she would leave me. About my mother-in-law, just before separation, she went on her own and set up a payment amount without discussing with us. About the family letters I had written in August, October, and December 2022 to friends and family. I used the phrase that if you are interfering and alienating the other parent and you use the children to hurt the other parent, that can be construed as domestic violence. Father's Day fell on June 18th. The visit mom initially proposed was 90 minutes at a park, with her parents invited. My attorney pushed back. The visit became 6 hours at my house, directed by the children's attorney. The children arrived. None of them would look at me or my parents. They went straight to the bedroom and locked themselves in again. I made lunch and put it on the table. The conversation that followed happened over text through the closed bedroom door. In the group chat Claude analyzed, my oldest spoke for the group. I left the plates on the table. They did not eat, but according to phone records, made phone calls to their mom and mom's mom. I drove them back to the exchange in silence. That same week, I noticed my name in the children's group text had been changed from Dad to Mr. Gilly. I asked Mom about it. She replied that she had noticed it months earlier, had addressed it then, and that morning had checked all the phones, all of which she said still showed Dad. By her account, it had been corrected. Claude observed that Mom's account didn't align with what Dad had seen in the record. The next major event was the hearing itself, a 2-day proceeding to decide whether Dad's visits should be eliminated or Dad given full custody. Day 1 fell on July 10th. Day 2 was set for 1 month later. Day 1 on July 10th, the petitioner's case was presented. Mom's attorney called 5 witnesses: Mom's mom, her father, her, my mother, and my father. No witnesses called by the guardian. None called by my counsel that day. Claude noted no counselor, no therapist, no clinician, no expert. On cross-examination, my attorney closed the abuse question on the record. Claude notes that the abuse Mom alleged in front of the judge was verbal, psychological, and emotional. My attorney: you didn't allege abuse in this case at the time of the filing of the petition, did you? Mom: no. Attorney: you never called the police during the time of your marriage. Mom: no. Attorney: you never called Child Protective Services during the time of your marriage. Mom: no. Attorney: there's no medical record of a doctor being informed of any kind of form of abuse prior to the filing of divorce in this case, correct? Mom: correct. The guardian ad litem cross-examined Mom. Claude describes the guardian's posture from the transcript as adversarial against the very motion the petitioner had brought to court. She walked Mom through the planning of our son's birthday party, set for 1 hour at 11 a.m., with no advance notice to me that it would be the only opportunity. Then she pressed Mom on what evidence she had presented that day to warrant suspending Dad's visits entirely. I'm going to let you read what Mom said. It's too difficult for me to read aloud. Mom's mom testified under oath that she interacts with all 4 children daily. She described anxiety symptoms each child had exhibited before the filing. For each child, asked whether the symptoms had increased, stayed the same, or decreased after the filing. She answered decreased. Claude noted that the children themselves had told the police something similar in November 2022, that everything had immediately changed when Dad left. On cross, Dad's attorney returned to the counselor's withdrawal. Mom's dad's testimony took only 9 pages. His professional credentials were not surfaced at the hearing. On cross, my attorney extracted one thing that mattered. Between January and April 2022, Dad had taken the kids to church by himself most of the time, with Mom staying home. My dad, called as an adverse witness, had videoed visits at a park and at restaurants in February and March 2023. The children turning their backs, not speaking, running and hiding. His words, quote, "These are kids that loved us." 28 hours after day 1 finished, the guardian ad litem stepped onto our OFW thread directly for the first time. Claude observed her substantive recommendation. I should attend my daughter's birthday celebration the following weekend, and my separate request for father quality time should be granted. The guardian was operating consistent with the posture she had taken in court, against suspension, protective of the father-children relationship. What followed across the next 30 days operated under that posture, against a parallel track. Mom proposed unilaterally enrolling our 2 oldest daughters in public school. The guardians supported public school for the kids, and I had offered the larger and more equipped public school where I lived about 30 minutes away. Mom said, "How children are educated is a decision to be made by parents, not attorneys." 11 days later, on the day of the deadline, she enrolled them anyway. Her account on the day of the deadline, she said, quote, "I was advised to proceed since the deadline was today." She declined to identify the advisor. The girls started at public high school on August 3rd, 7 days before day 2 of the hearing. I attended the family birthday celebration on July 15th at a park with 2 friends who did not stay and flowers for my daughters, whose birthdays we were marking. My daughters refused the flowers when I tried to give them. A second visit followed on July 22nd. Mom's dad came over to make small talk. I told him matter-of-factly that I had not come to visit with him for hours. I called him a fraud. His response, "No, I am not, and I am proving it to your children, and you aren't because you still don't get it." The day before that second visit, I sent the 4 children a text inviting them to take bike rides on the visit, copying Mom on the thread. All 4 responded separately. Each named the same 3 people as their source of safety: Mom, Nana, and Grandpa. My youngest daughter put it most simply: "I only feel safe around Mom, Nana, and Grandpa." 4 children, same 3 people, same day. I wrote to the Guardian on July 25th, registering my position. I told her that Mom's parents had helped create the problem of fatherless children through delusional false allegations, and were now solving the problem without regard to the children's actual father. It's a diagnosable behavior, I wrote, and it's a repeating pattern for them. Day 2 of the hearing was August 10th, which also would have been our 20th wedding anniversary. Mom's attorney called me as adverse witness. The exam ran over 100 pages. He took me through the November 11th, 2022 police call audio, line by line, asking whether I recalled the children using each specific word. To the living in a nightmare articulation, I told the court I would agree with them. What I meant, and what I didn't put on the record, was I would agree with them in reference to this process that I had nothing to do with and never wanted anything to do with, and still don't. Mom's attorney took me through the parental alienation theory. When he asked why I had written intimate details of my marriage and Mom's medical history to 6 close friends and family in the August 2022 letter, I told the court, "They do need to know that she abandoned our marriage. She abandoned our family." On cross-examination, my attorney took me through what I had been trying to do with the family letters. He asked, "When you wrote those letters, did you feel like you were trying to save your wife and save your marriage?" "Absolutely," I said. "I am very open to reconciliation. This is Katrina under the influence." When my attorney asked what my proposal was for resolving the children's rejection of me, I told the court, "I think the kids are in a state of hysteria. I believe they think they can just divorce me and hold out. I genuinely believe that if at this very moment you said, 'Hey guys, you got to go live with Dad,' I think they would be in an emotional freakout for about a week, and then I think they would go, 'Oh.'" My attorney examined the guardian ad litem. She testified for the only time in this case. 3 passages from her testimony anchored the case. The first was about the family. She described an intact unit since 2019 with the children carrying everything that had been going on. The second was about my framework. She would not use the words parental alienations professionally, saying that diagnosis had to come from a clinician. But when my attorney asked whether she had observed children being distanced from their father at mother's home, she answered yes. She added that both parties made poor communication decisions about the kids. The third was about evidence and timing. When my attorney asked whether she had evidence Dad had been abusive, her answer, the short answer, is no. She confirmed the children's rejection behavior had begun after the petition was filed, and that Dad's contact with the kids had been very limited since the petition was filed. Her recommendations: all 4 children in public school and individual counseling, a reunification counselor, visits starting at 4 hours and incrementing up. She named Trey Trotter as acceptable, a therapist who claimed she had experience with parental alienation, and my attorney said she was maybe the only option in the area. Judge Colling ruled at the end of the day. The motion for in-camera interview of my older daughters, denied. The motion for attorney fees, denied. The petitioner's motion to suspend my visitation, rejected in substance. The court modified the visit structure: 4 hours per Saturday, 1 to 5 p.m., at my house or a public location at my discretion, with 72 hours advance notice. All 4 children placed in individual counseling with Michael Smith, reunification counseling with Trey Trotter, the new clinician. I would bear the cost of both. No video or audio recordings during visits. The court's framing came in the ruling. On the children's autonomy, the judge said, what a 17, 15, 12, and 11-year-old child want is not necessarily what's in their best interest. They don't get to exercise a veto power and just decide to unilaterally terminate their relationship with their father. On the recording prohibition, he said, that's got to be terribly traumatic to the best interest of these children to be going to visits and having various people pointing phones at them, taking pictures, videoing. They hear all that. They cannot be in their best interest. And the review hearing was set for November 9th. 2 days after the ruling, I wrote the Guardian 1 paragraph. I appreciated her testimony that Thursday. I had taken to heart her concerns about my children's mental health. While Michael Smith would not be my first choice, I will do everything I can to accommodate and cooperate with my kids' receiving counseling from him. I committed to sending her and Mom visit notes weekly through OFW going forward, and I followed through on that. The motion to suspend had been substantially rejected. Michael Smith was back in clinical contact with all 4 children. A new clinician, Trotter, would take over reunification therapy. I would bear all of the costs. At the time, I felt completely validated. There was no basis for Mom's accusations, and the judge effectively restored my legal fatherhood. Except, he left it to Mom to communicate with the kids what happened. Would the kids get the message that they had never been abused, and everyone but Mom and her parents believed it was safe to reunify with Dad? I was very hopeful a qualified therapist could actually help.